Well, hello everyone, and welcome to One Civil Law. So I wanted to do a follow-up video relating to Karen Reed because I've seen quite a lot of confusion online related to the charge that has been given with respect to DUI and how that lays in for a lesser included. So we're going to discuss this in the context of the jury verdict slip that was provided as this trial. So this jury verdict slip is different than the last jury verdict slip in the last trial because there's a new number 5. The last verdict form did not have number 5. Number 5 is been added, and it seems to have been added at the explicit request of the defense, which they apparently are allowed to do. Some states don't allow for that. Some states do. So we'll talk a little bit about what a lesser included is, but it seems to be at the request of the defense. They're the ones that want this here. All right. So first of all, we should probably discuss what a lesser included is because it makes sense why it's on this page. You will see at the top of the page, it says verdict slip, and then it says offense 2. That is the second charge. Okay. Manslaughter while operating a motor vehicle under the influence of liquor. And then you see 5 options. One that's not guilty, and then 4 different guilty options. So these are all options within count 2, but you can only select one of them. That's the key, right? You can only select one. Pick one. So one of these 5 options, not guilty or one of the 4 guilty options, you get to pick a pick. And what makes them all count 2 is that they're all lesser includeds. And what makes them lesser includeds is that every step down is all the elements above minus something plus nothing else. Okay, so I'm going to try to explain this in a couple different ways. All right, so suppose a charge has elements A, B, C, and D. All right, to prove guilt, you have to prove A, B, C, and D. All right, a lesser included, by definition, would be any combination of those with at least one missing, but no additional stuff. So A and B would be a lesser included. A and C would be a lesser included. C by itself would be a lesser included. A and D would be a lesser included, but not A and E, because E is something that was not in the top count, right? It can only have things that were in the upper counts, and it cannot have any new things. That's what makes it lesser included. And it also is critically, legally, the same charge for double jeopardy purposes. Okay. So you can only be convicted, obviously, of like the same crime once. Okay. So what makes something the same crime? Okay. What makes something the same crime? It's actually easier to state it the other way around. What makes it not the same crime? So what makes it not the same crime is if you have 2 crimes, each of which have an element the other does not, is what makes it not the same crime. Okay. So if I had A and B and C and D, those obviously would be distinct crimes because they each have an element the other does not. But also, if it were A and B and B and C, then they would each have an element the other does not. They both share B, but the first one has A, the second one doesn't. The second one has C, the first one doesn't. Okay? So as long as they both have an element, the other does not, they are legally distinct. Okay? So again, A and B, C and D, totally distinct. No one is confused. A and B, B and C, also legally distinct. They both share B, but the first one doesn't have C. The second one doesn't have A. Therefore, they are legally distinct. Okay? If that is not true, they are not considered legally distinct for double jeopardy purposes. Hence, why they are all listed within the context of count 2. Because every single one of these charges is not legally distinct in this sense. They all have elements of their parent, but there is nothing new, right? They're not adding anything. So they're all legally within the confines of count two. So if you were found guilty of any of them, right, you couldn't be found guilty of any of the other ones. And to the extent you were, you could only be sentenced once. So you'll sometimes see that, for example, in sentencing, where either you'll see courts say like, oh, like count two is dismissed as like the jury will convict on like counts 1 through 10. And you'll sometimes see judges say things like, oh, count two is dismissed as a as a as a course of law. And what they mean by that is like in that context, because they are not distinct, you can't be found guilty of both. The jury was presented with both, they returned both, but it's not possible to do both. So they'll obviously give the greater, right? If they convict of two and you can't do both, what's the court going to do? They're going to give you the more serious one, right? So that's one option. And the other option that sometimes you'll see courts do is they'll simply make the sentences concurrent, because then basically you're just serving the time at the exact same time. And you know, what's the difference, right? Because they're just now being served simultaneously, and so there's like no additional punishment, so it doesn't really matter. So that's another solution you'll see courts do, but that's the reason why they do it, is because of that reason. Okay, so I'm going to also give you another example about lesser includeds from another example, just to sort of highlight the point. Okay, I'll give you two examples. All right, every murder includes the crime of assault. Okay, it would be really, really hard to kill somebody without assaulting them. In fact, it's impossible. It cannot be done. So every single murder includes the lesser included of assaults, because of course it does, right? So every murder is an assault. Not every assault is a murder, right? Because that's what makes it a greater, right? Because every murder is necessarily an assault, because assault is an element of murder. It has to be. But of course, not every assault is murder, because that would be, you are adding things now, right? If you found A, B, C, and D, you obviously found D. But if you only found D, you didn't necessarily find A, B, and C, right? It only works one way around. So every murder includes an assault. That's relatively easy. I'll give you another example. Every robbery includes a larceny. Robbery is when you steal something from somebody by force. Larceny is when you steal something. Obviously, if you're stealing something from somebody by force, you're also stealing something, right? So every robbery is a larceny, but not every larceny is a robbery, because if you steal something from somebody by force, you obviously stole something. But if you stole something, you didn't obviously steal it from them by force. The greater includes the lesser, not the other way around. So hopefully that's relatively easy to understand. So that's what's going on there. Okay, great. All right. So in the confines of this case, or in the confines of count two, strictly speaking, right? Because there are three counts. There are three counts in this indictment, right? There's murder, manslaughter, and leaving the scene of the accident. Okay, there are three counts. Count two, as you can see, includes 4 exciting options, but only one of those things, and they're not all equal as well, which we'll get to in a second, right? They're not all equally created. Just because they're lesser included doesn't mean they're all equal in terms of punishment. Sometimes that's true, sometimes they're not true. It's not true here, but they're all lesser included. All right, so you can choose one of the following 4 exciting fun options. All right, so exciting option number 1. Manslaughter while operating a motor vehicle under the influence of liquor. Now, right away, you should be able to determine, without me telling you anything more, that obviously, if it's manslaughter while operating a motor vehicle under the influence of liquor, operating the motor vehicle under the influence of liquor is a lesser included, because I just told you, right? It's manslaughter while operating a motor vehicle under the influence of liquor. So it's 2 things: manslaughter while operating a motor vehicle under the influence of liquor. So operating a motor vehicle under the influence of liquor is a lesser included of manslaughter while operating a motor vehicle under the influence of liquor, because it's right there in the title. It told you. Like, we didn't even have to go to the elements of the crime or anything. It just told you flat out right there, like it's right there in everything, right? So it's 2 things. It's manslaughter and also operating. So obviously, operating the motor vehicle is itself a lesser included. A lesser included can, of course, be a crime unto itself, as it often is, right? manslaughter, a murder includes assault. Assault is a crime unto itself. Assault is also an element of murder, right? A crime can be a crime unto itself and also an element of another crime, right? So assault is a crime unto itself. It's also an element of murder. Larceny is a crime unto itself. It's also an element of robbery because that's what a lesser included is. Great. So in order to find guilty of manslaughter while operating a motor vehicle under the influence of liquor, well, it kind of told you in the title, you have to be under the influence of liquor and you have to done the manslaughter. In this case, by driving on a public road in a reckless way, leading to the death of John O'Keefe. The public road, of course, being the road in front of 34 Fairview because it's a public road. So yeah, that's relatively trivial and unto itself. That's not that hard. Hopefully not that hard. All right, and then we've got the lesser included of involuntary manslaughter. Well, again, I mean, duh, right? It's manslaughter while operating a motor vehicle under the influence of liquor. So the manslaughter itself is obviously a lesser included of the manslaughter while operating a motor vehicle, because again, it's in the title, right? So the involuntary manslaughter is lesser included. So that you got that. Basically, you intentionally did an act that was reckless that led to death. That is basically the definition of manslaughter. Intentionally performing an act in a reckless fashion that led to death. That's basically manslaughter, and that's relatively easy enough. Then we get to the lesser included of motor vehicle homicide, which is now just a felony DUI liquor with negligence. So now we only need negligence, but also with the DUI, because normally negligence alone is not going to get you there, right? Normally it's not sufficient, but here we're adding something. Like negligence is not normally enough for like manslaughter and murder, I should say. There are some crimes for negligence, but not many. Usually you need like at least recklessness. Negligence, simple negligence usually is not a thing except in some fairly extreme scenarios for criminal penalties. But in any event, in this case, the add-on here is the felony driving under the influence, which is in most jurisdictions is considered inherently reckless anyway, because driving under the influence is really, really dangerous. So that, kind of gets you there anyway. So then basically all you have here is you're operating the motor vehicle in a negligent way, which, if the greater with the manslaughter while operating the motor vehicle requires recklessness, and simple negligence is lesser than recklessness. So that's negligence is a lesser of recklessness. And of course, we already had the felony DUI in the first place. So that's obviously a lesser included. And then just straight, no nonsense, operating under the influence of liquor, which of course is a lesser included of the manslaughter while operating a motor vehicle under the influence of liquor. So all those things. So that is how we're doing that legally. I hope I explained that relatively well. It is a little complicated, but basically, if you just remember what I said earlier about, for it to be a lesser included, it must only have elements of the greater and nothing more than DUI by definition, which they call operating a motor vehicle under the influence. They call it OMI, whatever. They can call it whatever they want. DWI, DUI, call it whatever the fuck you want. It doesn't matter. It's all arose by any other name at that point. But in any event, it's obviously a lesser included, but it is not manslaughter. So if they check box 5, even though it's listed again at the top sheet, right? The top thing said offense 2, manslaughter while operating a motor vehicle under the influence of liquor, right? But if they only check box 5, they are not finding her guilty of manslaughter, which is slightly confusing. But it makes sense to the lawyers, but it might be a little bit confusing for you. I'm not trying to insult you. It's just a little confusing because you see the top count like manslaughter, and you would think that every single option here is manslaughter, but it's not. It's not. Number 5 is just straight, normal, uncomplicated DUI. That's all it is. It's just straight, uncomplicated DUI. by itself as a naked bare charge. It is a lesser included of the offense. It has to be, because again, it's right there in the title, right? It's right there in the title. Manslaughter while operating a motor vehicle under the influence. So you know right away that operating the motor vehicle under the influence is a lesser included. It has to be. So it is properly listed under count two. It is a lesser included of count two. It would be legal error, or it would be at least legally confusing to put it in a different place. So it's legally correct, but it's not manslaughter. So that's exciting. Incidentally, by the way, the possible penalty for this offense for DUI is 2.5 years. And because then when you get to the penalty, obviously, of DUI, right, because someone died, that can be factored in sentencing. So you would imagine it will include some jail time as a result, even if they don't find, the manslaughter, but they just find the DUI. But then we get into whether or not the death itself is an established fact. Is actually pretty interesting at that point. Yeah, then we get into the interesting issue of, like, is it proper actually to factor the fact that the person is dead into sentencing at that point, which we'll get into a legal fight over sentencing at a later time. But let's press on for the moment, because that's already too complicated as it is. But yeah, all those things. And then, like, another thing that people are a little bit confused about when it comes to this, it's like that there's not like a breathalyzer test, or not necessarily a blood test. And there doesn't have to be, right? Those are obviously evidence and strong evidence, but it's not actually, strictly speaking, legally required, right? So when the police pull you over for DUI, they're going to do a whole bunch of things normally, right? They're normally going to do probably a field sobriety test. They're normally going to do a breathalyzer. They might do a blood draw. They might do many things. But strictly speaking, they don't necessarily have to do those things in the strictest possible legal sense, right? All they have to do is gather evidence that will convince a jury beyond a reasonable doubt that you were under the influence, or with a blood alcohol level of 0.08 or greater. Either one will be fine, by the way. So 0.08 or greater is just an automatic, like, you're under the influence by definition. But if you're under the influence just at any level, but under the influence, that also is sufficient legally. So, if you're at 0.07, but you can establish to a jury that they were under the influence of liquor, then that's also DUI in this jurisdiction. And incidentally, by the way, most jurisdictions define it that way. Obviously, normally they just go with the, like, 0.08 thing, but strictly speaking, they don't have to in many jurisdictions. Strictly speaking, they can just charge you with operating under the influence, even if you're, like, at 0.07. Now, how they can prove you're under the influence might be a little bit trickier, but strictly speaking, they can in many jurisdictions. And again, like, the fact that there wasn't a breathalyzer, the fact that they didn't pull her over this all, by the way, is obviously at the time that the alleged murder happened, by the way, in case we're curious about the time frame in this would be her being drunk at, like, 12:30 in the morning on the night in question, basically, right? So that would be when she would be DUI, incidentally, is when we're doing this, because that's the event. So yeah, obviously they didn't do a breathalyzer then. They didn't do a blood draw then. They did do a blood draw at a later time, but whatever. They didn't necessarily even have to do that, right? They can prove DUI some other way. And they've tried to establish that by, showing her drinking at the bar and showing her drinking glasses and trying to establish that she had so much alcohol that she would have been drunk. And if you buy all that, then, you can get there legally, sufficiently, right? I mean, you don't necessarily, I get, like, just to prove the point that you don't necessarily need a breathalyzer, or you don't necessarily need a blood draw, just to, like, prove the point. Like, suppose that you saw someone, like, walk into a regulated liquor store, right? It's Bob's Liquor Store. It's been there for 20 years. It's a fully licensed and accredited liquor store. There's nothing special about it, right? You see someone walk into Bob's Liquor Store and they go to the shelf where the vodkas are, and they pick up and you watch them do all this. I'm just telling you, you're there to observe it all, because you're just very observant. You see this person go to the liquor thing, pick up a bottle of vodka. You then watch them check out with it. You then watch them go outside the liquor store and chug the entire bottle of vodka, and then get in their car and drive away. Okay, and you call the police, as you might do, and the police, 3 days later, catch up with this person, and this person invokes their right to remain silent like a good person, and the cops want to charge them with DWI. Can they charge them with DWI based on what I just gave you? You bet your ass, right? You bet your ass, assuming that you're a credible eyewitness in this scenario, which we're going to assume for the purposes of this exercise. And by the way, also, there's no like surveillance footage, and the clerk at the store can't remember anything to save his life, so he's not available. Don't worry about it. There's no surveillance footage, and there's no the clerk is dead. Whatever. You're the only witness to this thing, but you're a credible person, and yet, like, I saw him come in and get the liquor bottle and get it and chug it outside, and then get in the car. I mean, it was pretty memorable. I remember the whole thing. I remember exactly what car it was too, because of the bumper stickers on it. It had the my kid goes to Elvira Elementary, and I love band, and the whatever, and it was a Ford Explorer or whatever, and blue one, and so you can identify this car sufficiently reliably. And yeah, can the police charge DUI? You bet your ass. Can the jury convict on DUI? You bet your ass. If they buy your story, sure, why not? Right? So I mean, that's just to prove the point, right? The police don't necessarily need a blood draw. They don't need a breathalyzer. They don't need these things. These things are obviously helpful to them, but they are not, strictly speaking, required. All that is required is for them to put together evidence that will convince a jury beyond a reasonable doubt. And however they do that, is sort of up to them. But yeah, the lack of a breathalyzer or lack of a blood draw is not fatal to this case. So yeah, there's all those things. So hopefully all that is relatively clear. The lesser includeds appear to have been requested in response to chat, where the lesser includeds add by the judge. It appears that they were done at the request of the defense. It seemed to be the defense that was asking for it, as best as I can determine. If you go listen to the charge conference, the Commonwealth, the way it sounded, didn't want any lesser includeds at all. The way it sounded, at least, they didn't want any lesser includeds. So the way I heard it, at least, is that the defense was the one requesting all the lesser includeds, including this new exciting lesser included. So it wasn't the judge doing it spontaneously. I'm not even sure the judge can do it spontaneously. I'm not even sure that's possible. But in any event, it seems to be the defense that wanted it for whatever reasons that they wanted it. You do need either 0.08 or intoxication. That is absolutely true, right? You need one of those two things to be true. So either 0.08 or intoxication. But of course, in my hypothetical, where you saw them chug the entire liquor bottle, I think a jury would be more than able to draw the conclusion that they were over 0.08. That's why I made the hypothetical absurd. I wanted to make the hypothetical absurd so we didn't have to have that fight. Right? It's like, oh yeah, they chugged the entire bottle of liquor and then got in their car and drove away. Yeah, it's probably greater than 0.08. Yeah, not a lot of problems believing that one. So yeah, but yes, you do have to prove one of those two things. Absolutely, that's true. Why would they want it? That's a good question. I've been talking to people about this, and we've been talking about it and trying to figure it out. The only thing that we've been sort of able to devise in this is, as you will recall, they have acquired a juror from the previous trial who is now one of their lawyers, right? Because a lawyer was on the jury last time and was kicked off the jury, as I'm sure you will recall. And so the lawyer turned juror turned lawyer again. The only thing we can think is that the lawyer turned juror turned lawyer has said that based on deliberations, that they the previous jury just really wanted the option, and that's one of the reasons that they were having such problems. They really wanted the option, and it wasn't an option. Apparently, that's one of the things that they were having issues relating to. I don't know how wise it is necessarily to act on that, because every jury is very distinct, and what jury one jury will care about, another jury will not care about at all. But apparently they thought it was an option, and or they thought it was a concern, and they thought it was a concern enough to add it, I guess, to give it as a compromise verdict option. So I that's the only, I mean, that's got to be the rationale. It's like we'll give them something that they can get, that they can check yes to, if it'll make this thing go away. So I guess she was not a deliberating juror. That's true. Yes, she was kicked off the jury before they deliberated. That's right. She was kicked off, which is a whole nother thing unto itself. But yes. Oh yes. So that why would she know? That's a good question. Because she wasn't a deliberating juror. So how would she know what the previous juror wanted or thought? Good question. Don't know. All right, I'm back to being confused. Never mind. I retract my previous point, and now I'm just confused again. I don't know. Maybe she thought it was a good thing for other reasons, or maybe the jury talked when they weren't supposed to. Hmm. Maybe jury one was talking about the case before they got the case. Maybe that's what was going on. Could be a lot of things. Ronnie said it though. Okay, there you go. So maybe they know it from Ronnie. The jurors talked after the trial. Some are still friends. That too. That would be another way that she would know. Fair point. She might have learned it since then from talking to members of the jury, because of course they're free to talk to anybody. So maybe she learned it that way. That's also fair. If Karen is convicted, a juror said that holes in the sweatshirt was a major factor. What happens? Nothing. Nothing. That information will never be available. What happens in the jury room stays in the jury room. There are very, very few exceptions to that, mostly relating to bias or external influence, which this would not be. This is neither bias nor external influence. So that information will never be available. So it is a non-factor in any appeal. There's no reason the jury should pick the foreperson first, then alternates. I agree. It's bizarre to me that that's apparently a thing in this jurisdiction. I don't get that at all. But yeah. The DUI, the only one that does not include a collision? Yes. Yeah, the straight DUI charge does not involve a collision. It literally, all it requires is all it requires is that she was driving drunk. That's it, or under the influence. But yeah, well, I guess that's driving drunk. Either way. Yeah. So yeah, all it requires is that she was driving drunk. That's it. End of analysis. Yeah. You meant in an interview. I understood what you meant. I understood what you meant. Like if a juror after, like I understood what you meant. If a juror if she's convicted and a juror in an interview or some other way for that matter revealed that the sweatshirt was a major part of their deliberations, it wouldn't matter. It is a non-factor because it doesn't matter. We don't pierce the jury veil ever. Well, except in, again, bias or external influence situations. And so this is not that. That information will never be part of the record or any appeal. It would be irrelevant. Yeah, someone said the foreperson took no notes. For what it's worth, I think Turtle Boy said that juror number one was his favorite juror. I don't want to misquote the man, but I believe remember seeing that he had listed the jurors in his order of preference. I believe he said that juror number one was his favorite. And just because you're not taking notes, that doesn't mean you're not paying attention. Some people takes more notes than others. I don't take many notes compared to some people. So, you know, yeah. So I don't know how important that is, but you know what, for whatever it's worth. I wonder how Paula Margaret will resolve if she's convicted of DUI. The wording's unclear. I don't actually think it is unclear. I think it's actually pretty clear the way it was phrased, but that's Polly Market's problem. Let's see if there are other comments here. Andrea Burkhart was reading through the legalese and apparently figured the judge can on her own without approval from defense or prosecution. That would be weird to me if that's true. Andrea Burkhart is one smart cookie, though. So if she actually said that, I believe her. She does not talk out of turn. That strikes me as odd, but okay. But I do think it was the defense that wanted it, based on everything I understand. The defense certainly didn't seem to object to it. They're like, we don't want that, which yeah, they didn't seem to object to it. So I think the defense wants it for whatever reason they want it. If you watch them chug it, we still need proof they're driving long enough to absorb. Fine, law girl. All right, just for you, we will amend the hypothetical because I'm God of the hypothetical and I can do whatever I want. After this person after this person chugged the entire liquor bottle in front of you, they then hung around for 15 minutes before getting in their car and driving away. Fine. Picking apart my hypothetical, that's just mean. I understand how it works mechanically, but I don't understand how if you choose the standalone DWI that somehow you get to say guilty on the manslaughter charge for betting odds. Well, the way it was written, it wasn't the manslaughter charge. It was much more specific. The way it was written in the poly market it was much more specific. So I think they're okay for the betting pool because I don't think it was charged too. I think it was much more specific the way it was phrased. The person in seat 1 is juror number 5. Okay. Well, what did Turtle Boy say about juror number 5? Where'd that go on the list? It was ranked 4th. Okay. Well, there you go. 4th then by Turtle Boy. Still pretty good. I mean, if it's his 4th favorite, that's still pretty good. So hey, you could do worse. If it comes prosecutor and judge can conspire against you, what's the point of a trial? Yeah. Well, yeah. Corruption is always possible. How do we deal with corruption on a systemic level? We've done our best, but we're all fallen, and so what can you do? What's the four-person's duty? The four-person's duty is literally the four-person's duty is to try to corral the cats. The four-person's duty is to try to make sure everyone has a fair opportunity to speak and sort of lead discussion and sign the bottom of the verdict form. That's about it. And also write the notes that go to the judge. That's the four-person's job. So that's what the four-person does. Either you believe a witness or don't. That's fine, James. I mean, that's obviously your prerogative, but jurors obviously can split that more more discreetly. Discreetly is exactly the right word. And they can split it more discreetly if they want, right? Jurors can believe in whole and part, not at all, and then of course they can decide how much it matters. So yeah, that's sort of all within the province of the jury. Yeah, they gave the jury an out if they have a moron who needs a charge to avoid another mistrial. Maybe that's exactly what the defense is doing. I mean, I understand a lot of, yeah. I mean, I guess it makes sense. I'm still not sure about the withdrawal of the missing witness instruction. The defense had wanted an instruction whereby the jury would be told that, like, the fact that a witness wasn't called, you can, like, hold it against them. And then the defense withdrew that request, which I thought was slightly odd. But they have their ID, they have their thing. Oh, by the way, while I'm here, I'd also like to correct the record slightly. On Twitter, I had said, in evaluating AJ's speech, that one of the things I would have liked would have been to end with an enumerated list of the reasonable doubts. And so I only gave him 9.3 because there was no enumerated list. I have since learned that there was a ongoing enumerated list being displayed to the jury while our argument was happening. So the enumerated list was being visually presented to them, which is even better. So I have since amended my score to 9.8 accordingly. I apologize for the error. Retrial should have 3 judges and no juries. Interesting idea. Why the audit not come into this case? Oh, well, a lot of it, the audit didn't really have anything to do with this case as such, as memory serves. I didn't read the audit. I didn't really do, but I skimmed it. I don't remember the audit really having anything to do with the case. It had to do with a lot of systemic issues, but it's a little off point, basically, is probably the short answer to that question. If convicted of DUI, can Bev have her served 2 years, and wouldn't that make it technically a felony? Yes, actually, no, it's not technically a felony, but it is. All right, all right. We have to. All right, this is a subtle point. All right, your firearms rights are stricken if the crime you're convicted of has a sentence option of more than 1 year. It doesn't matter actually what you're sentenced to for the purposes of 18 USC 930. So as long as you're convicted of a crime, the maximum sentence of which is more than a year, then you lose your firearms rights. It doesn't actually matter what you're sentenced to. As to whether it's a felony or not, it's actually, I'm pretty sure, considered a misdemeanor. Now your question is fair, because when you ask lawyers, like, what the short definition of a felony is, like, every lawyer will tell you the short definition of a felony is if it's more than a year, right? That's the usual line of demarcation for a felony. Usually, right? Usually, if it's less than a year, if it's a year or less, usually it's a misdemeanor. Usually, if it's more than a year, it's a felony. However, usually is the operative word, and sometimes you have felonies with sometimes you have misdemeanors with greater than year penalties. I seem to remember the biggest I've ever seen is 5. A 5-year misdemeanor is the biggest I've ever seen. But states do weird shit. So yes, hypothetically, you could have a 5-year sentence and a misdemeanor all at the same time, and also that would deprive you of your firearms rights. Law gets weird sometimes. We have 50 states, people. Okay, we have 50 states in DC, plus some territories, plus federal law. There's a lot of it. I do my best, but I'm learning things all the time. And I've been doing this since 2007. I've been doing it for 20 years, and I'm still learning things because the states keep coming up with new shit, or I keep learning about new shit continuously, because there's a lot of shit. It's a lot of things. I do my best, but yeah, it's some fun stuff. Lord have mercy. For a first offense, well, for what the sentence would be, typically what you would do is the sentencing guidelines for that, right? And so And also, I don't know whether or not the death can be factored in or not. I honest to God don't know. I don't know whether or not it can be factored into a DUI or not. If she's just convicted of DUI, I honest to God don't know if the death of John O'Keefe can be factored into that or not legally. So we'll consult the sentencing guidelines and we'll have that debate another time, man. That's why I asked two questions, not one. I knew it was based on maximum, not actual sentence. No problem. I'm happy to clarify for everyone. Right. So I wasn't meaning to insult you by giving the long-winded explanation. I was just trying to explain to everybody how that works so that everyone would be informed. But I appreciate that. I wasn't trying to insult you. I'm sorry if you did felt insulted. If she's convicted of the DWI, OWI, yeah, we can call it anything you want. Different states call it different things. Can we just come up? Can we just come up with a single thing so we all can call it the same thing? No. This is why we can't have nice things, because we have to call different things different things. And then some states have different. They get it's the states. They're just complicated. There's first degree murder, second degree murder. Sometimes there's third degree murder. There's voluntary manslaughter, involuntary manslaughter. I'm pretty sure in some states that comes in degrees too. Criminally negligent homicide, vehicular homicide. It's hard to keep track of it all, man. There's just too many things. Yeah, it's not automatic 2.5 years, correct. It's would have that would be sentencing, and then for that we would go to the sentencing guidelines. I'll worry about it if she's convicted. If she's convicted, I'll start worrying about whether or not we can factor in the death or not, and I'll start worrying about what the sentencing guidelines are. If she's convicted, I'll deal with it then. At the moment, my brain is full and I don't want to play. Why is the lesser charge of DUI under manslaughter? We spent the time talking about it. It's not just manslaughter. That's the thing, though. It's not just manslaughter. It's manslaughter while operating a motor vehicle under the influence of liquor, as you can see at the top right here. Manslaughter while operating a motor vehicle under the influence of liquor. So it is a lesser included because obviously it's included. It's right there. So it's lesser because it's fewer things, and it's included because it's included. So putting it on this sheet is a legally correct option for sure. Regardless of whether or not it could be put on a separate sheet or not, it is legally correct to put it on this sheet. So that's fine. If she's convicted, the judge sentences her in this jurisdiction. So it will be up to Judge Bev, who I'm sure will find reasons to give her as much time as the law allows. She will find a way to give the maximum that she can get away with. Whether or not that's 2.5 years or not, I do not know. We'll figure that out another time. But whatever the maximum number is, she's going to do that, I'm sure. They should have included open container. Well, actually, open container is not a lesser included of DU. It's not a lesser included. Open container is not a lesser included because, of course, you don't need to have an open container for a DUI, right? You don't need to have any alcohol in the car for a DUI. So open container could not be listed because it is not lesser, because it adds a new thing, namely that there's alcohol in the car. That's a new element. You can't do that. You can't add a new element and have it be a lesser included. That doesn't work. Thanks, Team Brittany. Team Brittany is here. Yay. How you doing, Team Brittany? Good to have you here this morning. I'm in a reasonably good mood today. So I'm going to hang out with you guys for a while and chill. We're going to hang and chill because I love you guys and I'm in a positive mood. When I'm in a positive mood, I like to extend that feeling for as long as I can. Sometimes I stream and I'm not in a good mood. Today I'm in a good mood. So let's keep the feeling going. In New York, I don't think they have a lot of discretion with sentencing. I worked as a paralegal in state prison law firm for 3 years. Tons of sentencing appeals. I only saw one get changed. I'm not sure if that means they don't have a lot of discretion, just so much as whatever discretion they use, they usually get right. I mean, to be fair, discretion is a lot, right? I mean, the judge, whatever it is, and we can get into it later, the standard is abuse of discretion. So, like, it's obviously possible to abuse your discretion, but that's really hard, right? When you're appealing on an abuse of discretion standard, that's really challenging because judges get a lot of latitude. It's like judges are minor gods, they get a lot of latitude. So, there's that. If she gets acquitted on all charges, do I think the murder John will be investigated by the FBI? No, almost certainly not, because not for at least the reasons I don't think the feds have jurisdiction. The feds don't really have jurisdiction here. What would be the federal hook, right? And I don't know that there is one. Yeah, if you, I mean, in order for it, even for like 18 USC like 240 like 1 or 243, like for acting under color of law, they'd have to be acting in their official capacity. So you would not only would John O'Keefe have to have been killed by like one of the cops, but I'm pretty sure he would have had to been killed by one of the cops while in the official performance of his duties, which is not an allegation. So I don't think there's a federal hook here. So yeah, the feds in our system, we have a very interesting system of law in the United States, as I'm sure you guys and some of you overseas appreciate. Perhaps it's very complicated. Um, the federal government doesn't have as much power here as I think a lot of people think they do. This is a completely understandable confusion, though, not for at least the reasons that in some countries, like to the extent that there are like states or provinces or the equivalent there too, like really serious crimes are prosecuted by the federal authority, not state authority, like in some systems of government, right? Our system of government is different, right? As you know, like there's no like seriousness threshold, right? All crimes of all seriousness are tried by states. The federal authority is completely independent of state authority, so you can be tried by both in our system of government, which is also somewhat unique compared to other forms of government. You can be tried by both the feds and the states. They can both have a crack at you because it's separate sovereigns. But the federal authority is fairly limited. You need a federal hook. So you need some way for the federal government to get involved. For similar reasons, incidentally, if Karen Reed is convicted, I don't really see the feds coming in and saving her. There's really no mechanism by which the feds can come save her. There's just no mechanism. The only real mechanism that exists is habeas corpus, and in order to get a habeas relief after you're convicted, you have to show clearly established law by the U.S. Supreme Court. Which, good effing luck, right? I mean, there's just not a lot of Supreme Court cases out there. Habeas relief, yeah, especially it's basically borderline impossible in many situations. So yeah, the Fed's jurisdiction here is very limited. The Feds obviously could investigate the police for being corrupt for other reasons, but that wouldn't get them to John O'Keefe. Like if you're asking about investigating the murder of John O'Keefe, the Fed's jurisdiction is non-existent, basically. If you're asking about them investigating the police for corruption, then that would be for basically going after Karen Reed. Then there's a federal hook, right? Because then you would have the police acting in their official capacity to deprive Karen Reed of her rights. So if they can make a sufficient showing for the police depriving Karen Reed of her civil rights, in this context, probably her Fourth Amendment rights seem the most plausible, then they could prosecute for that. But the federal jurisdiction here is very limited. Could Trump step in? No. Trump can only pardon for federal crimes. And at the moment, there is no federal crime that Karen Reed is charged with, nor is one even really possible. So nothing there. I don't understand this. If they find her guilty on the DUI charge, then wasn't this trial pointless? I don't know. It will be the most expensive DUI conviction ever. I'm quite sure. Between this trial and last trial, it'll be the most expensive. It'll be the most expensive DUI conviction ever. How much time will Karen get? Up to 2.5 years. Deleting another cop and a cover up is in federal territory? No, not unto itself. It's not. No. Just straight murder of a cop is not federal territory. No. If you go and kill a cop today, please don't. But if you go and kill a cop today in broad daylight, as it were, unless it's a federal cop, no, there's no federal jurisdiction there, unless you did it in a federal building or on federal land, exceptions and so forth. But no. And cover up isn't territory? No, not really, unless that cover up amounts to a deprivation of rights in some way. If Karen Reed wins, will prosecution have to pay court and attorney's fees? Nope. No. No, she's not going to get any money for this unless she sues them. And suing them will be challenging for all the reasons that it's always challenging, suing the government. Her best bet in suing is probably with respect to Proctor, maybe some of the other police officers on Fourth Amendment grounds. There's something in there somewhere, but she won't get money just because she won. Is there not guilty box anywhere for all counts? At the top of the page, at the top of each page, there's a not guilty option, which they did take the language from last time for the sake of clarity. So not guilty of the offense charged or any lesser included offense. So there are 3 not guilty boxes, 1 for each page, because there's 3 counts. So 3 boxes. If convicted of DUI, then isn't that saying she hit John and killed him? No. No, if she's convicted of DUI, it's saying she drove drunk, period. That's it. That's what a DUI is. Saying she drove drunk, period. If there are bribes and other things going on in the DEA office, could the feds get involved? Again, to the extent that they're acting under color of law to deprive her of rights, then yes. Right. If again, you don't even need really the bribe though for that. I mean, the bribe is helpful, although actually bribery unto itself. Oh God, there is a statute on that, isn't there? I'm pretty sure there is. Yeah, I believe it is actually illegal under federal government. I believe it is illegal as a matter of federal law to bribe state officials. I'd have to double check, but I think it is illegal unto itself. So yes, if you can prove a bribe, I think that actually is illegal unto itself, and also that you don't necessarily need the bribe if you can show the basically the conspiracy to deprive her of civil rights, that will be fine. RICO? No, it's not RICO. There's a special law for it. There's a special law dealing with bribery. I think it's 18 USC 666 actually. If I got this by memory, I'm going to be impressed with myself, but I think it's 18 USC 666. Yeah, I think it is 666. Let's take a look. Where's my share screen thing? No. 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 Yes, great. All right. 18 USC 666. Theft or bribery concerning programs receiving federal funds, which incidentally, like most state police departments do, because they get federal funds for lots of things. Federal money is everywhere. Finding federal funds is not the challenging thing. Yeah. Whoever in circumstances described in subsection B of this section, being an agent of an organization of a state, local, or Indian tribal government or agency thereof, which would be the police, corruptly solicits or benefits or demands for benefit of any person or accepts or agrees to accept anything of value from any person, intending to be influenced or rewarded in connection with any business transaction or series of transactions of the government. Yeah, that's pretty much there. Or corruptly gives or agrees to give anything of value to a person with intent to influence or reward the agent of the state or agency thereof shall be fined not more than 10 years or both. So yeah, So bribery is illegal if they accept federal funds, which I'm sure they do. So 18 USC 666. I remembered chapter and verse. Excellent. My memory's not so bad today. Aw, I really enjoyed being on Melanie's channel too. I'm looking forward to hanging out with her on Monday. It was fun. I had a great time. I'm looking forward to hanging out with her on Monday. Would they appeal if Karen is charged with a DUI? Almost certainly not. No, almost certainly not. Well, I guess they could appeal for the same reasons they could always appeal, to be honest. But I mean, their appeals are equally viable for that. So I guess they could ask. I guess they could. I don't know whether they would or not. I'm not sure. Maybe. I don't know. Good question. Dever is done as a police officer. Not a chance. Not a chance in this world. Not a chance. Not only is she not done, she's going to get a promotion. She's going to get a citation. She is the opposite of done. Her career is bright. I am confident. I am confident. She understood the assignment and she will be rewarded accordingly, I am sure. DB Plus 499 said, "Thank you, Kurt, for all your hard work and wonderful snark. You're welcome." Can Karen Reed start a GoFundMe? Strictly not a GoFundMe. I don't think they allow it for that. But as crowdfunding goes, yes, and I believe she's already done that. She has crowdfunding, but she's so far in the hole that short of a very rich benefactor coming along, yeah. The blood pool wasn't valid for court cases according to their own lab. Would that not be cause for appeal? No, not necessarily. No, because again, like it's not, yeah, it's not the thing, right? It's like if the blood draw is all the evidence they have, then that could be a problem, but it's not in this case. So yeah, no, I don't think that's going to be a problem, right? Because they have other evidence indicating DUI from video footage and Karen Reed's own statements and so forth and so on. So yeah, I don't think you're going to have a problem on that one. She'll never step into another courtroom. I don't know about that, man. I don't know about that. Yes, I do constitutional law cases. There are six that dropped on Thursday. We haven't covered yet. I'm saving them for jury watch. Because I need to talk about something while we're doing jury watch. So I'm saving them for jury watch. We'll see if maybe Melanie will need a break. Maybe Melanie will need a break break her own stream. And maybe I'm like, Melanie, would you like to take 2 hours away from your own stream? Take a break, do some errands or something. I got it covered. No problem. I'm just gonna do 6 Supreme Court cases while you're gone. I got content. So we'll see. Maybe we'll cover it with Melanie. We'll see. Yes, Karen can just be found guilty on the DUI. That's exactly what the thing. Yes. No grifters today. The grift today is not very real, but that's okay. No broken bones means he didn't get hit. Well, it's evidence of that, certainly. What about the guy who walked out of an airplane crash with just scratches? Well, it depends on the nature of the airline crash, I suppose. It depends what kind of crash we're talking about, and also a lot of other factors. But like, is it possible? Sure, it's possible. But like, beyond a reasonable doubt, I don't know, man. Right? Freak things happen. Freak things happen. But we're trying to prove something beyond a reasonable doubt, is at least the assignment. Right? So, like, if the plane crashes, do you think beyond a reasonable doubt you're going to get injured? I do. Maybe you get lucky, but yeah. Yeah. Sometimes things hit in just the right way, and sometimes you get lucky. But freak accidents, even if they're fortunate accidents in this case, freak accidents, even if they're fortunate, are not really the thing there. Kurt doesn't know about the crash guy. Kurt has been a little bit busy with the Karen Reed case and other things. I didn't really know. Not so much, no. Thanks for keeping the conversation going. No problem. Thanks, Lynn. 1/200 seems like reasonable doubt. I've most lawyers, if you ask them what reasonable doubt is, if they put a percentage on it, would say something like 95 to 99%. So you're talking about 5 to 1%, something in that ballpark is what most lawyers would say beyond reasonable doubt looks like. That's the numbers I've heard, at least bandied about. You might hear a little bit higher than that, but that's basically the ballpark of what beyond a reasonable doubt looks like. So John didn't have any broken points. I guess this freak accident. Thanks, Kurt. Proved my point. Well, I proved it's possible, but again, the standard here is beyond a reasonable doubt, right? You're not applying the burden in the right place. Yeah, it's possible. I never said it wasn't possible, but the question is, can the state prove it beyond a reasonable doubt? That's the real problem, right? That's the real problem. Under the state's theory of the case, two things need to be true at the same time. Like no matter how you slice it, right? No matter how you slice it, under the state's theory of the case, two things need to be true at the same time. Karen Reed needs to have hit John O'Keefe with enough force to create a disabling injury, yet simultaneously not created any broken bones, torn ligaments, or bruising. That's the challenge for the state. And they need to be able to prove that beyond a reasonable doubt because it's the state's burden. They need to prove that that's possible. Not only possible, but they need to prove it's what happened beyond a reasonable doubt because that is a necessary conclusion. It is a required conclusion of this scenario, right? It is required that she hit him with enough force to create a disabling wound of some kind, but not bruising, broken bones, or torn ligaments at the exact same time. And they have to prove that beyond a reasonable doubt. So me saying yes, it's possible doesn't prove anything. It certainly doesn't prove it to you beyond a reasonable doubt. So, like, if we're applying the right legal standard, right, then it's not enough. It's not enough that's possible. Freak things can happen. It doesn't mean it's what it doesn't mean the state proved it at all. I don't know why the FBI started looking into this case. Can't speak to the FBI's interest in this case or not. I have no idea why the FBI looked into it. Do a fast recap of what she can be found guilty of, and that doesn't really lend itself to a fast recap. I guess I will advise you to just go back and watch the stream after it posts. It doesn't lend itself to a quick discussion. In case of not guilty, In case of not guilty, does including the lesser include taking those charges off the retrial too? Yes. Yes. Not guilty is guilty of the entire count. So it's guilty necessarily of any lesser included, even if they weren't charged. So even if the lesser included weren't included in the charging document, they're they're gone for double jeopardy reasons. That's what makes them double. That's what makes it double jeopardy. So whether they are on the verdict sheet or not, any lesser included is gone. Whether they're included on the sheet or not. If I was a juror, I'd vote not guilty easily. I mean, how do you get to proof beyond a reasonable? How is there proof beyond a reasonable doubt that she hit him, and how's there proof beyond a reasonable doubt that she hit him with enough force to create a disabling injury of some kind, yet simultaneously not create broken bones, torn ligaments, or bruising? How is there proof beyond a reasonable doubt as to that? And there's not. So this case fails for that reason. And since the state has to prove each and every element of the charge, right? If they fail us to even one element, I don't have to keep talking because they failed. So I don't have to worry about any other elements because it doesn't matter anymore. So having found one element that they fail, I can just stop talking and not guilty by definition. So it's easy. How do they fill a verdict 4 on charge 2 if they consensus not guilty in 4 but hung on 5? They don't. Yeah, they don't. If they can't come to a resolution on 5, and they can't come to a resolution, then they can't check any of the boxes. They have to check one of the boxes if they're going to check anything. So if they can't come to a resolution, if they think not guilty as to some of them, but not they can't get to the entire page, then they can't check anything. They have to be able to check something. They can't do it. At least the way the verdict form is currently presented. I suppose they could ask for permission, but not the way the verdict form is presented. Anything further? I'm enjoying our time together. We do have some nice merch. I delisted the limited edition mug because it was limited edition, so I delisted that. But we do have some other cool merch. How do I think he died? I have no opinion. It's not my job. See, that's the thing, right? That's the thing. Within the confines of Commonwealth versus Reed, I have only one job in the end. That's the thing that people forget. Within the confines of Commonwealth versus Reed, I only have one job. In the end, did the state prove each and every element of the crime? That is my only mission in life. I do not believe they proved each and every element of the crime. I have no further questions. I have no further questions to answer. Not my circus, not my monkeys, not my job. Don't know, not my problem. See, when you remember the question, it simplifies. When you remember the question, it makes everything much simpler. Not my problem. Any cases lined up for the near future? Well, we're going to cover the Supreme Court cases at some point in the near future, hopefully. Do I ever wish I was a criminal lawyer for any part of it? I don't know. I don't think I could do better than Jackson. Like, the only real reason for me to want to, well, other than just like my own pure personal thrill, but the only real reason for me to want to be involved professionally is because I think I can do better, and I don't. I don't think I could do better than Jackson. I can critique Jackson. I can point out areas that he was not as good in, but I don't think I could. I don't think I could actually outperform him. I don't. Yeah. So I don't think. Yeah. Yeah. I can't reconcile the injuries with John O'Keefe being struck by a vehicle either. Yeah, that just doesn't work for me. It doesn't work for me. So yeah. Yes, either impaired or over 0.08. That's correct. One of the two, which is pretty typical. That's typical in most jurisdictions. I think closing went too far into third party. I've thought that too, but as someone else on Twitter pointed out, that sometimes you really need to give the jury a possible alternative suspect. You know, if you don't give them something else to look at, that can be a real problem, which is a fair point. So yeah, maybe they had to for that reason. There is no possibility whatsoever of getting the case moved to another state. That is not possible. And as for getting Beverly Canoni recused, well, there's not really possible either, man. So that's not happening. Does it frustrate me to see the bias of Judge Bev? Yep. Would it matter for the conviction of DWI whether a report was written by the police? Nope. No. Doesn't matter. Doesn't matter that there's no report by the police. That doesn't matter. No, they don't. It's not required. If I was a prosecutor, which witness would I have left out? Interesting. Burgess comes immediately to mind because I don't think I need him, and he just causes me more problems than I had. And Burgess comes immediately to mind. Is there anyone else that I would exclude as the prosecutor? Burgess feels like the biggest cell phone. Um, mm, yeah, that's the only one that really comes to mind off the top of my head. The federal hook is not RICO. I don't see. No, RICO doesn't make any sense. Bev does not have discretion to send Karen Reed to jail for DWI for 25 years. Who told you that? It's 2.5 years. Walsher? Mm, no, Walsher is fine. It's sad that I couldn't have done any better than that, but apparently. Did I notice when the clerk called the first two seat numbers and the last four as juror numbers? I didn't really notice, not in particular. If Higgins involved, can that be a federal hook? Uh, not unto itself. There's no way they can get guilty ever. I wish that was true. I really do. I mean, I'm still basing my calculations off of a random jury. I'm not basing my calculations off of the demographics of this jury or any jury observation. So when I give this number, it's based off of like just a random jury that I don't know anything more about. But I would still project 20% to convict as as a reasonable projection for all the reasons I previously said. Clerk interchange seat numbers with juror numbers. I didn't really notice. No one else seemed to notice, as far as I could tell either. No one else was like raising a conniption about it. All right, guys. Well, I guess I'm going to go ahead and sign off for now. I think we've sort of exhausted this topic, and but I had a lot of fun discussing it. We can continue the conversation going on Discord anytime. So if you guys want to hang out on my Discord, that's a pretty good place, to share your thoughts relating to Karen Reed or other cases, or share cases you want to be discussed. It's a good place to hang out. So make sure to check out my Discord. Give you the link in chat, and do that. And I will hopefully see you guys on Monday, probably with Melanie, and that will be fun. I will talk to you later for now. All right. Bye bye.